Yes, I'm Jay Wilkinson, and I've been a judge on the Federal Court of Appeals for the Fourth Circuit since 1984. President Reagan appointed me, and I think more importantly, I'm a father of two children, and just had my first grandchild not so long ago. Yeah, I think it's, I try to think to myself, well, what can we do right? What can we do and what shouldn't we do? And I think of this Constitution of ours as a scolding parent, and it waves a finger at government. And it says, you may not do this, you may not do that. It's like a parent, this Constitution of ours, talking to a child and says, you may not infringe freedom of speech, you may not infringe the free exercise of religion, you may not conduct unreasonable searches and seizures, you may not discriminate on the basis of race, color, or creed, you may not deny someone of their right to counsel, or their right to cross-examination, or their right to subpoena witnesses on their own behalf. You may not coerce confessions. You could, on the one hand, look upon the Constitution as a constant scolding nag at government, and judges are I think, extremely well equipped to enforce these do-nots, which lie at the very core of American liberty and at the very core of who we are. And when a branch of government begins to trample on these very fundamental rights, you're going to find the judicial ears perking up pretty quick at that. Okay, that's what we can do well, is enforce the constitutional do-nots. What we don't do particularly well is to take leave of the document itself, wander away from the law, start creating all these unenumerated rights which just have no textual grounding. When we get away from the law by creating these unenumerated rights, we're out on our own, and we don't have the very thing, the law, that gives us respect and authority in the eyes of the people. Then we just become legislators in our own right, and that's not good. And when we leave enforcing these do-nots and interpreting statutes and sticking close to the law, and we start leaving the enforcement of our enumerated rights and start trying to draw up all these tests for checking the enumerated powers of a coordinate branch of government, we're taking a big step. So you always have to, it's like you can't see too well, and you're trying, as you navigate these cases, you're trying to hold on to a railing at all times. And that railing should be your constant companion. And that railing is the law. And the law is made up of all these wonderful raw materials, the chief of which is words. I mean, the rule of law is a rule of words. And what we did when we framed that magnificent Constitution of ours is we exchanged bayonets for words. That's what we did. We said, lay down your arms. We will not have the rule of arms. We will have the rule of words. Okay, but the quid pro quo for the rule of words is that we take words seriously. And judges, most of all, have to take words seriously. And if we go fabricating stuff without a strong textual basis, we get on thinner and thinner ice. And got to understand, everybody needs to understand what they're good at and what they're bad at. We have certain things we're very good at, and we have some other things that, well, we need to stay away from. Well, we have a system where there are 1,000 answers. We can't. These questions are so difficult that you can't expect. Often, you can't expect any one single answer, and you take a question where people take a question such as reproductive rights, and there are going to be many different people with many different views on that. And one way to look at it is that there shouldn't be any one answer, that there ought to be a dialogue among different people with different views, that people ought to, in the political process, listen to one another's views respectfully, if that's possible, on these very flammable subjects, but that it's not wrong for the American system to supply different answers. It's not wrong for Texas to go in one direction and for Rhode Island to go in another direction. It isn't wrong to have these things in a constant state of communication and dialogue and evolution, because they involve questions that are so important to people's deep moral beliefs and to their faith and to the rest. And it's very difficult, unless the judiciary has a strong mandate in law, for the members of the legal profession, even if they happen to be on the bench, to be telling financial analysts and plumbers and school teachers and firefighters and IT specialists and everybody around the world, everybody around the country, this is what you should think about this question. We can do it if we have a strong constitutional mandate. But it's hard to say my way or the highway to 300 million people when you're only 5 members of the legal profession. I wouldn't want a wonderful profession, but I wouldn't want bankers telling me what I had to do with respect to to the way I feel about some of these very volatile questions. I don't think they want lawyers telling them what they should do on this, unless we have a solid grounding in the law, and then we must move. Oh, it's not backing away. See, some people think restraint is abdication, but as a judge, you need to say, it's not always what do I decide. It's may I decide. You have to ask that question, may I decide? There are questions that you need to just respect what the legislative branch comes up with. That's not abdication, that's not backing away. Now, suppose the legislative branch hasn't come up with a solution. Well, that doesn't mean we're going to charge in. I mean, what, are we supposed to exercise the power of the purse and set out appropriations? Are we supposed to decide how the sequester is going to be administrated? It would be preposterous. We don't have the tools, we don't have the institutional expertise or the staff expertise or whatever, and sometimes you have to say it is best for someone else to decide. You would say to me, well, but suppose they haven't decided. Well, that all goes back to what you mean by decide. And sometimes, again, decision is going to take a lot of false starts. It's going to take, before we come to a resolution of a question, there may be 2 steps forward and 1 step back, 3 steps back. because democracy doesn't move in an even line. And sometimes we just need to let it all play out outside the courthouse walls. We need to let it play out. And I certainly understand what you're saying, and that's why I tried to say this is not a matter of absolutes. In other words, among the great constitutional do-nots is the 14th Amendment. Do not deny any citizen equal protection of the law. 15th Amendment says you must not deny someone the right to vote. And the 14th Amendment is one of the great amendments to the American Constitution, and it is one of the clearest, which is that do not discriminate on the basis of race. Whatever else you might say, that's a core principle. The decisions in Brown versus Board of Education and Loving versus Virginia and many other civil rights decisions of the Supreme Court, those were among its greatest moments, Brown and afterwards. And of course, Plessy and Dred Scott were among its most tragic moments. But this goes back to what I said. I think Brown versus Board of Education, completely justifiable. And the same thing with a case like Loving, because they're firmly within judicial enforcement of the Constitution's famous do-nots. The 14th Amendment is part of that scolding finger that says what government may not do. And so those were great days for the judiciary in Brown and many other civil rights cases when they stepped in to vindicate the right of every American citizen to be considered for whom he or she is, and not on some deeply unfortunate criterion such as race.